A special cabinet meeting following a shocking declaration by the North Gauteng High Court. It ruled that government didn't entirely follow the constitution in implementing alert level 3 and 4 of the lockdown regulations. Minister in the Presidency, Mthembu, says COGTA Minister Dr. Nkosazana Dlamini Zuma will lead government in approaching the court to seek leave to appeal the judgment. Mthembu says government will make the application on an urgent basis.
After obtaining legal advice and listening to numerous comments made by members of the legal fraternity in reaction to this judgment, we are of the view that another court might come to a different conclusion on the matter. Cabinet has therefore decided to appeal the North Gauteng High Court decision.
Meanwhile, the special cabinet meeting has agreed that the national state of disaster will be extended by another month until July the 15th.
Cabinet also approved the extension of the national state of disaster by another month from the 15th of June to the 15th of July 2020. As we all know, the national state of disaster can only last for 3 months or 90 days.
Mthembu says President Cyril Ramaphosa will visit the Western Cape this Friday. The province's continued rise in infections has been a cause for concern, and it has been dubbed the country's COVID-19 epicenter. Abongile Dumako, SABC News, Pretoria.
Joining us now to discuss is the Director of Werksmans Attorneys, Bulelwa Mabasa. Bulelwa, thank you for being with us tonight. Before we look at government's decision to appeal, can you just give us your take on that earlier judgment that said the regulations under lockdown level 3 and 4 are unreasonable and unconstitutional?
Yeah, thank you for having me. I think the mainstay, or rather the main principles that can be derived from the judgment are around the well-established test on rationality. In other words, that whenever a public entity or government or state entity exercises power, it should do so having rationality as the center and guiding force of the issue. It also highlights a well-established principle that such decisions must be underlined by rationality, lawfulness, and reasonableness. The questions around whether or not the judgment is sound are really whether or not the court has gone far enough in or had enough before it in determining the irrationality of some of the regulations that it found to have been irrational.
And it's pretty difficult because it didn't look at all the regulations and say these are unrational, unreasonable, these are not. It just took a sample and then said everything's invalid. So it creates a huge task for government if it had wanted to pick through those anyway.
Yeah, I think if I were to be advising government, I would be saying to government that the imposition of the lockdown was found to have been constitutional, so that takes one issue. The imposition of the fact that there's going to be a phased approach in opening up the economy was an important one. I would take that other issue. The third issue, the big question for government now is, as the government reopens the economy, it has to do so in such a way to minimize harm and risk to individuals as much as possible. But more importantly, it has to be guided by the necessary WHO protocols. In other words, if the guiding light is around flattening the curve, and if it is around all the intricacies that are needed in order to flatten the curve, then the content of such regulations must be met with that intention.
So your thoughts on government's decision to appeal, how successful do you think that will be?
Look, I think it's going to depend pretty much on the approach that's going to be taken by the Supreme Court of Appeal, whether to concentrate on the substance of the regulations that, you know, the court of first instance found to be regular. I think it's likely that the SCA is going to say that the court did not have enough before it to apply the irrationality test. But I think more importantly than that, government will have to show how and whether or not those regulations meet the rationality test. In other words, that those anomalies that were identified in the judgment by the North Gauteng High Court, that those are actually dealt with. So when you talk about prospects of success, yes, there are aspects of the judgment where I think the court misdirected itself, but I think more importantly, it's going to be around whether or not these regulations are indeed rational when you look at some of the consequences of, for example, having a sole proprietor not being able to conduct his business, although he can show that actually he can take the necessary health protocols, versus, for example, some of the decisions around allowing churches to continue operating with a limit of 50 people. So it's going to be around, when the decisions are made by government to reopen the economy, what are the driving forces that come to those, that influence those decisions? Is it health protocols, WHO, or does government also take into account issues that are actually not linked with the purpose of the lockdown itself?
Well, from government's perspective, it now means a lot of time in the courts when we're fighting COVID-19. From government's perspective, do you think cabinet members should look and say, well, maybe we've got some problems here with the regulations, or should they rather say this is a constitutional democracy? If we limit rights in any way, of course there will be challenges.
Look, I think it does definitely, you're absolutely right, and I agree with you. This opportunity does call for an opportunity for government to sit around the table and say, let us apply ourselves to which of these regulations are working, which aren't. And I think, the president has been very forthright in previously to point out where there's probably been, the overstepping of some of the cabinet members, or, having been overzealous, some of the issues around implementation and drafting issues in the regulations. So instead of taking a litigious approach, I think that it would have been more suitable to actually use this opportunity to improve and to clarify certain of the anomalies that arise from the regulations.
And government explaining today that the state of national disaster can only be declared for 3 months, then it has to be extended, but only on a month-by-month basis. So it has extended. Do you expect any contestation around that?
Look, interestingly, the North Gauteng High Court found that the imposition of the lockdown is completely constitutional, that there was a rational reason to do that. And if the numbers and the statistics, taking into account the scientific team that is advising the government, the National Council, Command Council, if the evidence points to the fact that there is a need to extend the lockdown, and that decision is based on solid scientific evidence, then I think there would be no basis to challenge a further extension.
All right. Thank you for your take. That was Director at Werksmans Attorneys, Bulelwa Mabasa.